So for our first topic, we'll talk about the basics of intellectual property. Something important to point out is when you have a video game company, nearly all of your value in that company is going to be in the intellectual property that your developers are creating, right? Maybe there's a couple key people in the company that are a valuable part of the company. Maybe they become sort of rock star developers. There's a lot of independent developers that have huge fan bases. However, most of it is going to be in the intellectual property itself. And it's not necessarily just the value of how much you can sell, how many games you can sell, and the trademark. But it's if you're getting investment, the intellectual property is what investors are buying into, and purchasing the company at some point. The value of the company is embedded in that intellectual property. And so if you're not properly registering it and protecting it and enforcing it, you could be doing your client a huge disservice, and I think diminishing the potential value of their company. So it's important to know this, and that's why we'll be spending, I think, most of the time in the CLE talking about intellectual property and how to get it protected. So what is intellectual property? I mean, we're going to go kind of basic for this first one, but we'll get through this quickly. Intellectual property is basically creations of the mind, right? Inventions and artistic works, symbols and names used in commerce. It basically comes in 4 flavors. The first one is patents. Patents are protecting inventions and ideas and mechanical processes. There's 3 main requirements for something to be patentable. It has to be useful, it has to be non-obvious, and it has to be novel. So it has to actually be something new. You can't patent something that already exists and people are already using. You get 20 years of protection on patents. And so I guess because they're ideas, they don't want to keep these new and useful ideas stuck with one company or one owner for too long. So 20 years is your limit on patent protection. The interesting thing about patents is it doesn't actually give you any affirmative rights. It basically allows you to stop other people from using your patent. So you don't actually get the right to use the thing that you've patented, because a lot of times there are so-called pioneer patents, which are sort of these new inventions, and then there's a bunch of patents that come afterwards that are innovating on that original invention, but maybe are sort of nesting that invention inside of them. So you don't necessarily get the right to use your invention if it's you may have to license that earlier invention in order to use your patent. Copyrights are the second kind of intellectual property. These protect original works of authorship. So, books, songs, dance choreography, and there's a ton of stuff in video games itself that is is copyrightable, and we'll get to that later. It's basically, it does give you an affirmative and exclusive right to make duplicate copies of your work, to publicly perform them. So if you have a song, you have the right to publicly perform that song out in the world. Create derivative works, so if you wanted to do different versions of your song, or you wanted to create a sequel to a movie that you've written, something like that. So that's one of the rights that copyright grants you. Copyright exists as soon as you create something and you fix it in a tangible medium of expression. What that means is you've taken a pen and you've written down your story, or you type it on the computer and you click save, right? That's when it's locked in a tangible medium of expression. And that's when your rights start. However, you can't really do much with that right because you're not allowed to sue anyone unless you've actually registered your copyright. So we'll talk about copyright registration a little bit later, and it's very important to do it and do it in a timely manner in case you actually want to enforce those copyrights. The copyright protection lasts for a long period of time. It's the life of the author plus 70 years, which could end up being a long time. If a company is the author, if a business is the author, then it can be as much as 120 years, but it doesn't go off of the life of the author. Unlike patents, So, yeah, with patents, you can't have independent invention, right? So if 2 people come up with the same invention at the same time, the first one to get the patent is the one that's going to own the rights to make that. However, with copyrights, you can technically independently invent the same thing. So if me and a guy in Seattle both drew Mickey Mouse at the same time and we came up with it, even if they're substantially similar to each other, we could still both have rights as long as we didn't have access to each other's and there's no actual copying. So copying is what they're looking for when they're infringing on copyright. Trademarks is the next one, and this is super important in video games, and we'll do a whole section about protecting your trademarks. Trademark protects words or symbols that identify the source of consumer goods. So it's a source identifier, and it's protecting two parties. So it protects the trademark owner from competition using their same trademark, but also, and what it's really protecting is the consumer. So if a consumer walks into a store and they want to buy Coca-Cola, they're going to look around and look for the Coca-Cola logo or the name, and they're going to pick that up so that they know when they see Coca-Cola, they know that they're actually getting Coca-Cola, what they've expected. If we allowed anyone to use the Coca-Cola trademark, that would make it be an issue because you could be getting, I don't know, Sprite in your Coke cans, and that wouldn't be good because they're trading on the goodwill of Coca-Cola, and we don't want that to happen. We want to protect the consumer so that they know what goods they're getting when they look for a trademark. These can be both state-based, common law, and federal. If you're doing commerce, so the rights under trademark accrue from when you're actually selling a good. Use in commerce is what they're looking for. So it doesn't have to be for money. You could be giving away a product for download on the internet, as long as you're actually transferring it to consumers in commerce. They accrue once you start doing that. So you start getting rights. So registration doesn't actually give you the rights. It protects your rights. And without registration, you're not able to sue in federal court, generally under the Lanham Act. However, there are common law rights that you could potentially sue under if you haven't registered your trademarks. So the state-based rights, if you're just geographically keeping, let's say you have one restaurant or a couple restaurants just within a state, you only have rights within that state in that geographic area. However, if you are crossing and doing interstate commerce, it falls under the Federal Trademark Act, and that's where the real protection is. So when you register your federal trademark, you get the right to sue in federal court. And another important right is you get the ability to stop or have U.S. Customs stop the importation of counterfeit goods. So if you've created a video game and someone in Malaysia or some other country is trying to import counterfeit versions, you can register your trademark with the U.S. Customs and Border Patrol and potentially have those counterfeits stopped at the border. Excuse me. So trademark rights actually they last as long as you're actually using the rights in commerce. So they could potentially never go away. That's why Coca-Cola's rights are still there no matter how long they've gone. As long as they're actually still selling products, as long as you don't abandon it. And I think if you stop using it for 3 years, that's a constructive abandonment, and it makes you have to rebut that by saying that you actually have plans to reintroduce the product. So the fourth kind of intellectual property is trade secrets. Now, these are interesting. These are secrets that derive their value from the fact that they are secrets. So they have some value in whatever business you're running. However, the other types of intellectual property, if you wanted to get protection under that, you actually have to reveal what it is and publicly register them. So your copyright, you have to submit a specimen that will show everyone what you are copywriting. With trade secrets, you're keeping them secret. So there is no public registration, and therefore they fall under state law. So each state probably has some version of the Uniform Trade Secrets Act, but you're generally trying to keep them secret. In order to maintain this protection under trade secret law, requires that it's actually a secret, that it has some sort of value in your industry, and that you're taking reasonable measures to keep it a secret. So those reasonable measures could be non-disclosure agreements, confidentiality agreements. You could be shredding things, implementing data security policy, with your digital secrets, restricting access to only the people who specifically need to know those secrets. Like the formula for Coca-Cola, I think, is only restricted to certain people that know it. And designating confidential information as confidential when you're handing it out, especially when you're doing it under confidentiality agreements.